Good morning, good afternoon, and good evening. Thank you for joining our fourth in a series of four on special education rights and advocacy. Today's topic is going to be dispute resolution. We are the Education Law Advocacy Project of SMERLS, also known as ELAP. So if you hear me say ELAP, just know that that's what we're talking about. Thank you to our co-sponsors, the Minnesota Governor's Council on Developmental Disabilities and Proof Alliance. We couldn't have done this series without them. So the conference information. This information that will be provided today is not legal advice and should not be construed as such. Laws change, and this information is simply a restatement of the law. If you are attending this video conference with someone else and haven't registered yet, please do so. That's how we share our video link, resources, and other information, which will be sent out later. We will take a 10-minute break around noon and address general questions for about 5 minutes before jumping into the next topic as we change from topic to topic. Please submit questions in the chat if you're interested in doing so, and we can try to answer them if they are pertinent to the topic we're discussing. If you have any technical assistance, you can message or email the assistant. Today's presenter contact information. So first, my name is Ruben Chapa. I am a parent advocate, law clerk, and advocate for parents in the Education Law Advocacy Project of Southern Minnesota Regional Legal Services. I've been with SMERLS for about a year as an extern and a law clerk, and hopefully I will be a staff attorney pending some bar law results. Laura Eisner is a staff attorney with Education Law Advocacy. She joined last summer, has been over a year with the Education Law Advocacy Project. Originally, she was a prosecutor in CHIPS and child protection. She's translated over here and has been a great help for our organization. And so what is SMERLS? As you saw at the front page, SMERLS is the Southern Minnesota Regional Legal Services. It's the oldest legal aid program in Minnesota and provides free, high-quality legal aid to people with low incomes in critical civil matters. We have 9 locations through our service area, which you can see on the right, which counties those are. To determine if you're eligible, you must be within our service boundaries. Income must be at or below 200% federal poverty guidelines. There's some asset limitations and other restrictions that may apply. Our services include everything from family law to housing, immigration, government benefits, elder law, and of course, education law. If you do have any questions or information was on that front page, please feel free to contact us and hopefully we'll be able to help you. Specifically ELAP, we are help students with academic issues, school enrollment placement, students with disabilities, student transportation, maltreatment at school. We also help with harassment and bullying, systemic discrimination, school discipline and truancy avoidance, and English learning instructions. If you do have any of these issues, again, please feel free to contact us. Our information was provided there. Today's learning objectives. People who participate or see this video later will learn about special education terminology, timelines, and common acronyms. You will learn about dispute resolution options when a child is facing disciplinary action by the school, dispute resolution options related to IEP disputes, and other dispute resolution options available to parents and children with issues not disciplinary or IEP related. Review on manifestation determination is where we're starting. If you hear me say manifestation determination, just know I'm talking about manifestation determination review. You may also see it as MDR. Manifestation determination reviews are meetings where parents of the student, the IEP team, and any other relevant school staff review information about student to determine if the behavior that caused the disciplinary action was caused by or have a direct relationship with the student's disability, and if the school's failure to implement the student's IEP was the cause of this incident. So it's twofold. Manifestations determinations must occur before 1, the school initiates an expulsion or exclusion of a student with a disability, or 2nd, if a decision by the school will impact the student's placement and the student has a disability because of this code of conduct violation. Manifestation determination meetings must be held within 10 days if a student with disability has one of 3 things: has been suspended for 10 days in a row, has been suspended for a total of 10 days in 1 school year. That means from August to May or June, depending on when September to May, June, whenever you start school or end school. Or if the school district is considering expulsion for a student with a disability. Manifestation determination reviews are finalized when they determined that one or two things occurred. The behavior was manifested by his disability, or two, the behavior was not manifested by his disability. If the school determines that the behavior was manifested by his disability, the team must reevaluate the student to include a functional behavioral assessment, FBA, if an FBA was not originally or most recently completed. You can see some more information about our FBA in our last conversation. If an FBA was completed, though, the team must develop or review a behavior intervention plan, BPI, and make changes to the plan to help the student cope with his behavior. If the school determines that the behavior was not manifested by his disability at the manifestation determination review, the student would get treated as a regular student that does not have a disability, which may result in suspension, expulsion, or an exclusion. The school must notify the parent. It must in the form of a notice of team meeting. A notice of team meeting must be provided to parents, which includes information like the purpose of the meeting, which in this case would be a manifestation and termination, the time and location of the meeting, as well as who will be in attendance. They just can't. It helps the parent know who's there. The notice must inform the parents of who on the IEP team has knowledge or expertise, special expertise about the child. That could be an occupational therapist or someone else related to that type of field. And the school must use interpreters or other actions as necessary to ensure the parent understands the proceedings of the IEP meeting for those Spanish, Hmong, or other non-English speaking parents. As we move on to the next part, summary on discipline. Some discipline is prohibited on student enrolled in one, preschool or pre-kindergarten program, an early childhood family education or school readiness, or typically K through third grade. For students with disabilities, a partial day dismissal is considered a discipline, is considered a suspension, and is prohibited under more recent law. Schools are prohibited from using exclusionary practices to adjust truancy and attendance issues, which is also part of the new law. And if a student is disciplined, suspended, he or she must be provided with alternative education. And so it's to a student who is suspended for more than 5 days, or if the student is awaiting a school board decision on an expulsion or exclusion hearing, and the period is extended for more than 5 days. Alternative education include examples like online education, pre-made handbooks, or things of that nature. Under Minnesota law, there are prohibited forms of discipline, such as delaying meals or recess is prohibited in most instances from schools. Schools cannot stop or have a student punished, which would delay his meals or his recess. Under more recent law, there are some prone restraints and physical holds that are no longer allowed. Under the Minnesota State statute, staff may typically use force that prevents the student from doing physical harm to themselves or others, but the staff may not inflict any form of physical hold that restricts or impairs the pupil's ability to breathe, restricts or impairs the student's ability to communicate distress, or place pressure on a student's head, throat, neck, chest, lungs, sternum, diaphragm, back, or abdomen. There's some new law on disciplinary complaints. Under new disciplinary complaint laws, the school must have a discipline policy, and that discipline policy must contain where any member of the school community may file a complaint regarding the application of discipline policies and seek corrective actions. If the school does have a decision, the parents and students will be able to appeal the school's decision, and schools will be required to investigate complaints within 3 days of receiving or identifying personnel who will must identify who will manage the investigation. So that could be the principal, counselor, or somebody else within the school. To protect reporters will be protected from reprisal and retaliation, so the school can't attack them after if they do report the issue. If an investigation finds requirements were not properly implemented, then the school will have to take corrective action to correct the student's record if they improperly suspended him or improperly failed to suspend the student. For exclusions and expulsions, the Pupil Fair Dismissal Act, PFDA, is a state law from Minnesota that specifies due process is required for the dismissal of students from public schools. No public school shall deny the due process or equal protection of the law to any public school's pupil involved in a dismissal proceeding, which may result in a suspension, expulsion, or exclusion. To define some of these words, if you may not be aware, an exclusion is an action taken by a school board the school board to prevent a student from re-enrolling or enrolling for a period of time. For an exclusion, schools can only maximum period allowed is 1 school year, remainder of school year. So if they get excluded in May, then they can only be for the rest of that school year. They can re-enroll in August. However, if that is in September, they could be excluded until the following school year. For expulsions are actions taken by the school board to prevent an enrolled student from further attendance. The maximum period for this is 12 months from the date of expulsion. So this one would be from May to May or August to August or however long the date is when the expulsion took place. For the due process here, and there are a few processes that the student is entitled to. Student has a right to a hearing unless the student and the guardian or parent waives that right. So both of them have to agree that they're going to waive the hearing if they choose to do so. There must be a written notice, and that has to be served on the student or and guardian, either by personally or by mail. And then the school must schedule within 10 days of the service of written notice, unless an extension not to exceed 5 days is requested for good cause by any of the parties involved, including the school board, student, or guardian. The second half, the hearing the student has a right to have the hearing recorded. The student or parent must have access to his student's record, and the student is entitled to testimony. And so for hearing the record, proceedings will be recorded and preserved at the district's expense. Testimony must be given under oath, and the hearing officer can issue subpoenas should they be necessary. To give the student access to student records, there must be a reasonable time prior to the hearing. Student and or their representative must be given access to all school records pertaining to the student, upon which the exclusion or expulsion may be based. And then testimony. A student has a right to compel testimony, present evidence of testimony, or not to testify if they choose to do so. They cannot be punished for not testifying if they choose to not testify. Once the school board makes a decision, the hearer makes a recommendation to the school board. The board may provide the parties with the opportunity to comment before making the final decision, and the board must issue a decision within 5 days of the recommendation from the trier. It must be based on the record and be in writing. Once a decision is made by the school board, they are entitled to an appeal, which must be done within 21 days of a decision, and the decision may be appealed to the Board of Education. School board decisions must be implemented pending an appeal. Grounds for appeal include violation of constitutional provisions, district exceeded a statutory authority, unlawful procedure, error of law, unsupported or by substantial evidence, or if the decision was arbitrary or capricious. The commissioner of the Department of Education will then issue a decision within 30 calendar days from receipt of the entire record and parties' written submissions on appeal. And then the commissioner has a decision to make. He can affirm the decision, meaning he's going to go through with what the school decided, remand for additional hearing if he thinks there's more information that can be gained, reverse the decision in favor of the school or the student if the decision was not made properly, or modify the decision outright. And then the commissioner's decision is final and binding after the time the appeal expires. Then the commissioner's decision is subject to judicial review should the school or the parent appeal that. For readmission plans, the school must prepare and enforce an admission or readmission plan. The plan must include measures to improve the pupil's behaviors, which may look like a behavioral BPI or a functional behavior support plan. And they can include things like social and emotional learning, counseling, social work services, mental health services, referrals for special education or 504 evaluation, or evidence-based academic interventions. The plan must include reasonable attempts to obtain parental involvement, which means the parent should be involved and the school has to try to reach the parent to try to create this plan with them. The plan may indicate the consequences to the student of not if they don't improve their behavior. Now on to Laura.
What you guys can see 100%. So, okay. So first off, we're gonna go into special education disputes, but I want to make sure we can talk about the IEP process first. It's just kind of like a regroup. A lot of this has been discussed over the last 3 sessions, but I wanted to make sure we're all on the same page before we start talking about the dispute resolution process for special education complaints. So this is our flow chart. I've emailed it out many times. We have how it typically should happen. There are certain things that must be in place. And there's some flexibility though as we go through this, and we'll talk about that, of course. So first is identification, and this is sometimes just called child find. But the school district must identify and locate and evaluate children, all children with disabilities who may require special education services. So that falls within our identification piece. After a child is identified, the next step can be an evaluation request for an initial comprehensive evaluation. It also can be that intervention services are offered first or discussed first with the parent. There are a lot of different types of intervention services that schools have implemented, depending on what the concern is and the communication that the school and the parent have. An initial comprehensive evaluation could be requested by either the school or the parent. Intervention services can still be attempted and used at this time, but as soon as an evaluation request is made, there needs to be a meeting. And so we typically call that a pre-evaluation meeting where the parent, relevant people from the school, maybe like the special education director, general education teacher, others would show up for our meeting and talk about whether or not an initial comprehensive evaluation is appropriate at that time and what needs to be in place for that. So as part of that, it's kind of a brainstorming session a little bit too. If there is a comprehensive evaluation agreement, then people will start talking about what needs to be done. Is it going to be specific academic assessments that will be done, observations? Are we going to have an IQ test? What's going to be all included in this? If there is not at least an agreement when the meeting starts, a pre-evaluation meeting is a really good meeting to have where folks can talk about why an evaluation would or would not be needed. And so a parent can present their information, their concerns about maybe having an evaluation or their concerns about not having an evaluation. And similarly for the school, they can share that same thing. Pros and cons of having that evaluation done. After that pre-evaluation meeting is done, if everyone agrees on certain things that will be done for the evaluation, a PWN, that's the prior written notice, will be written out and includes what's going to be done and by who, and if it's going to be teacher interviewing students, all of the steps that's going to be included in the evaluation. So that evaluation or that PWN needs to be sent to the parent, and then the parent will review it and decide if they agree with all of it. Do they agree with the evaluation being done? Do they agree with what the proposal is in the evaluation for the PWN? Maybe they want to have more peer-reviewed type of assessments included versus, observations that are less, structured, more informal. Maybe they like to have some of the informal stuff too, just to kind of balance it out, right? Is the PWN reflective of what the parent wants? If the parent does agree, they sign that PWN consenting to the evaluation and return it to the school. Once the school has it, they have 30 school days. So if there's holidays coming up, right, that doesn't count, but 30 school days to work on that initial comprehensive evaluation. If you have that pre-evaluation meeting and there's not an agreement, that maybe the school refuses to do the evaluation because they don't think it's a proper time to start it, there should still be a PWN that goes to the parent. So that meeting should result in some sort of documentation being sent to the parent that outlines what's agreed upon or not agreed upon in that meeting. Okay, so permission is given to the school for an initial comprehensive evaluation when the PWN document, that prior written notice document, is returned to the staff with the consent box ticked and the document signed. If the parent doesn't return it, an initial comprehensive evaluation cannot start. It will not go forward. There are other times in a life of an IEP where if a PWN is not returned, things can still happen. And consent is assumed at certain other points, but not with an initial comprehensive evaluation. There has to be that documentation that the parent consents to it. Okay. So it must be an evaluation that looks at all areas of suspected disability and not just like one targeted point. If, you know, my little guy, he has significant, well, I guess depends on, we are unclear. He has some issues with his sensory input. Like we don't understand how much he hears in his visual eyesight. So a question for us, right? So, but we don't want to have just an evaluation just on hearing and sight, right? We need to have it also on academics and intellectual. Does this, you know, what are we learning about his functional skills? So we need to have a whole broad overview of what we're looking at for this child on all areas of suspected disability and how it's impacting them in their educational setting. Now, just because we have this evaluation done does not mean that we're going to end up with an IEP. We could result with an evaluation that's completed that shows that the child does not qualify. So if the child does not qualify, then the parent should receive that PWN, that document that says this is the evaluation and actually, there typically would be a meeting, right, where they talk about the evaluation. We're not proposing an IEP. There is some sort of documentation that should go to the parent. Sometimes it's attached to the evaluation itself that just says that the child does not qualify and the team agrees that an IEP won't be developed. It doesn't mean that a 504 plan can't be developed. It also doesn't mean that if the parent disagrees and they want to have, you know, the team reconsider something or a different type of assessment done, that they have to agree that the child doesn't qualify for an IEP. There's still opportunity to have conversations and go back to the team and talk about why they don't qualify and if there was concerns about things that were missed. Okay, so if the child does qualify, that's us over here. I don't know if you can see my arrow. We would go down to the IEP development. So the IEP is developed through the team when they consider the strengths of the child, concerns of the parent, results of the evaluation that was just completed, and academic, developmental, functional needs of the child. All of that is put together and considered when they're developing the IEP. And the IEP then, which is our individual education program, and it includes multiple documents. It's not just one. I mean, it is often provided as one big packet, but really it's important to kind of think of each section as its own section. That the IEP should include then the current level of performance of how the student's doing, academically, functionally, behaviorally, socially, statement of yearly goals that can be measured, explanation of how these goals will be measured, and then the progress reports, how they're going to be sent out, explanation of how often the student's going to be with their regular peers in the regular education classroom. Your IEP should have an explanation as to whether the student will be taking standardized tests, and the date services will begin for the student. Okay, then we jump down to IEP implementation, and like we talked about before, in the previous sessions, the services must be in the IEP to be implemented. I had a parent that came to me and she was frustrated because the school did not have special education transportation set up for her when she switched schools. And she had transferred schools with this IEP in place. So I went through the IEP in the past school. I don't know how it happened, but transportation was set up and it wasn't in the IEP. So it, a gentleman's agreement or a gentlewoman's agreement between the IEP team and the parent isn't enough, right? To have it actually implemented, it should be in the IEP. And then people can rely on it, go back to it, and make sure that it makes sense within the services, programming, and supports that the child has. Now, at least once a year, the IEP should be reviewed. And we kind of talk about those IEP meetings to discuss progress, and that can be at any point, right? So we have this section down here. IEP meetings can really happen whenever there's any questions, concerns, struggles that are happening. And we'll kind of jump to that. So having that meeting is is a tool, and we'll talk about that a little bit in a few minutes here, but that's a good tool to have in your toolbox, just to have open communication with the IEP team as much as possible, to ensure that questions and concerns, struggles that the students is having are being addressed with the team and the people that are working with the student daily in the school building. Now, the IEP also must be developed yearly. So if you have an IEP meeting and you make some changes, okay, so my IEP is implemented and developed September. We have an IEP meeting in October because my little guy is struggling to, you know, finish all his homework in class and it's causing issues, right? So we might have a meeting in October, but then again, next September, despite our meeting in October, we need to have that annual meeting where we'll sit down and talk as a team, where we're at with goals, what we need to change for updating our goals. Has he met his goals? They should have been achievable. So hopefully we've made some strides. If not, what do we need to change for services, supports, programming, and just kind of review of the whole document together as a team. Okay, now this is our comprehensive reevaluation. That's this other block over here. So you have an IEP after your reevaluation. It's typically 3 years, then you'll have another reevaluation that will help kind of go through everything, collect more data, or see where we were at before, do some comparison based on past assessments with new assessments. If there's new struggles, particularly with COVID, I think the eLab team can say affirmatively that COVID had a really negative effect on a lot of our children's mental health. And so having a reevaluation to see what else we can do to support them, if there's new diagnoses that we need to consider, all of that should be done in a full comprehensive reevaluation. Now, this language is a little flimsy. It has to be done at least every 3 years, but it can be done sooner if the parents and the school agree. And it can not be done every 3 years if the parents in the school agree. So like if you have a child that's maybe going into their 12th grade, they're doing fine, and the reevaluation set for February, like maybe it's not needed and everyone agrees. Parents and school can also agree to just do a data review of the past past evaluation, collect some more data just on like assignments or attendance or whatever the concerns are. But everything, if that's the case, similarly to if the evaluation is going to be done before the 3 years or not at all, there needs to be some communication about that with the IEP team. Like, is that really in the best interest of the child? Like to make sure that they do well academically. And it's helpful for all to have things documented, just to be clear going forward. There also are ways that if this does happen, your comprehensive reevaluation could result in just improving your IEP, making a new IEP, that would then be implemented and then developed annually. It all has resulted in the child not qualifying any longer. And if that happens, the parents, whether they agree or disagree, will get documentation about the child not qualifying and then have to determine their pathway as how they want to move forward. And then just because you don't qualify for an IEP doesn't mean that the child wouldn't necessarily qualify for a 504 plan. Those are they're just two different worlds almost. I mean, they're both helpful for the child to make things more accessible and manageable for the child in school. IEP is a super rigid, very poignant federal law about how special education services need to be done. And it's a funding source, so it's written as to what needs to happen for schools and funding and whatnot. Whereas a 504 plan is a civil rights statute, right? And so it's just how can we remove barriers for a child to be successful? And it's just to make things more equitable. Or that's the intent of it at least. Okay, all right. So, and then the last thing on our flow chart here is this blue box here. It's the independent education evaluation. So it's abbreviated as an IEE, and this can be requested at any point. Similarly, that comprehensive reevaluation can be requested. Not that it happens all the time, but the school and the parent would need to agree about having a comprehensive reevaluation. that might shed some more light. So if you have an IEP, for example, that is implemented and then go to IEP meetings and there continues to be struggles with whatever's going on with a particular child, the parents or the schools can recommend that comprehensive reevaluation to be earlier than that 3-year mark. If that comprehensive reevaluation comes out earlier than that 3-year mark or at the 3-year mark, and it doesn't have information that is fully capturing what the parents' concerns are or the students' concerns are, or there's disagreement about how it was actually done, maybe it didn't follow the PWN, whatever. This independent educational evaluation can be requested. It can also be requested after the initial comprehensive evaluation that starts this whole process. An independent educational evaluation is an outside person or group of people that would do an evaluation on the child, and the school would pay for it. So if the school agrees, then the school pays and would work with the family to figure out how this is all going to be done, timelines, who's the agreeable people that are outside of the school that can do these types of assessments that need to be completed. If the school does not agree, then the school needs to file paperwork with the Office of Administrative Hearings to talk about why their IEE is appropriate, or why their evaluation or PW, documents are appropriate, and then the parents would be able to present information about why they need to have an outside look as to what's going on with their child. So this can be
We
asked.
do have two
Yeah.
questions. The first one is how are peers defined? Is it a legal definition from Heather?
How are peers defined? No, it's just like I can send you information on general education settings and that, but that's not peers is not a defined thing, I don't believe, an idea. So, but I can send you at least what the general education language would be about the general education setting.
And then our second question is from Jackie. How will the reevaluation of a high school student impact that student attending college and using the disability in college?
Sure. So there's okay. So a reevaluation of a high school student could offer some more information for a child, right? I mean, I think that's a really good point, Jackie. Like if you have a student that's going to go to college afterwards, maybe having more information would be helpful. I don't know. I haven't had a case where we would ever have considered waiving the 3-year reevaluation. And actually, if you do have a situation where maybe a high school student is going to be assessed in February and they're going to graduate in March, or not March, May, maybe asking for that evaluation earlier on so they can actually benefit from it would be more appropriate. So that would be something just to consider. But there is, I guess what I'm saying is there at least is language in the reevaluation law that it can be waived if everybody agrees. But it definitely could be beneficial in helping this child understand where they're at, what they need. IEPs don't follow kids to college. 504 plans could. If a child decides not to graduate and stay in high school, but maybe do like post-secondary type of courses while they're still in the high school setting, then they can benefit from their IEP. So this depends on what the disability is, what the desire of the child is, because they'll be 18, right, when they're making these decisions. Usually, they'll be making their own decisions unless there's some sort of, guardianship thing in place. But the reevaluation for a high school student, particularly for a senior high school student, if you're looking at a reevaluation that's close to graduation, you have the flexibility of not having that done or having a data-based reevaluation. I think the question would be, what's the most beneficial for the child going forward? Would it be more beneficial to have it done in September and try to get the school on board now rather than waiting? But I think sending off our young adults into college or even career with most information about what helps them learn and be successful is always a good thing. So and then if you had more documentation about a disability, now again, the IEP won't follow them to college if they do graduate high school, but trying to build a build a 504 plan based on that information, that might be helpful as well. They could take that evaluation, bring it to the college counselors, and just make sure that they can get more time on tests or whatever that looks like for them. Okay, so let's see here. Parental involvement here. So we've already talked about this, but again, I just want to make sure that everyone is on the same page going forward before we talk about dispute. So parents of students with disabilities have the right to be involved with the school decision-making process for education, right? So they should be able to participate in each phase IEP meetings to develop your IEP, review the IEP, revise it, how the evaluation is going to be structured. That's why this PWN, which we will go into again, is super important, just to have that communication between the school and the parents about what's being done, what's being proposed, what's being refused, and why. So, and then this, if you're going to have a meeting with the school IP team, or if you are part of the school IP team, then you need to make sure that the parent is informed of what that the right to bring people with them to the meeting with them if they need help. There also must be steps to ensure that the one or both of the parents of the child with a disability are present and are afforded the opportunity to participate by notifying them of what's going on, when, what, who, why, where, and scheduling a meeting upon agreed upon time and place. Okay, this is from a previous slide that I just plugged in to make sure we had a note about this. If the IEP team is not fully able to attend, there are ways that it could be permissible for an IEP team member to not be in attendance. So if the parents in the school agree in writing that a particular team member does not need to be there because they're not going to actually talk about that service or that part of the curriculum, that's okay, that's acceptable. If they are going to talk about a particular service or curriculum aspect, that IEP team member, either we need to work around and find a new date that works for them to be there. If that the parents want to move forward or the school wants to move forward and everyone agrees in writing to consent, the team member could miss the meeting, but they have to provide in writing their input. So it can't just be by word of mouth, a summary or whatnot. We need to have something in documentation from that IEP team member that has critical information about pieces that we want to change in the IEP ahead of time so that we can make good decisions at the meeting. Okay, so our individual
Hi, Laura.
education. Yeah.
Another question coming in from Tracy. The question is, if an IEP does not follow to college, should there be a 504 written before graduation so that some of those things would be helpful, do follow them in college?
It depends on the school and the relationship that the parents have with the school. I would worry that my concern is that if you write that 504 plan, that the school might try to follow that and not the IEP, and that IEP has more teeth. And so maybe like on the very last day of school, if you have a good relationship with the school, otherwise your IEP has a good accommodations, modifications, and support section, or can be built into a good modifications, accommodations, and support section. And that document of your individualized education program could be a really good stepping stone in developing a 504 plan for the college kid. So your IEP has a lot more data and information and supports than a 504 plan would. So I think working with the team could be helpful. Just it depends on the relationship. I would be worried that there would be a confusion that the 504 plan would be followed and not the IEP. But if you're at the, what do they call it, like the senior slide or whatever, like the last month of school, and that's what you want to work on, that possibly could be a good route, so you have something to take to the college. But otherwise, that I mean, the whole IEP could be presented, or in more succinct information, at least the accommodations, modifications, and supports is a lot of the similar language that we actually, it's more detailed usually, but it's a lot of similar language that we can see in the 504 plans that are being developed. Okay. Yes, and that's a good point. Jackie pointed out that there's a vocational rehabilitation about that point. And then also, there is in your IEP, there should be transition stuff as well to make sure that that child is being able to be successful in going to college, right? And so if you're worried about how college is going to look and making sure the child has proper supports, that could be something as you're having with your IEP team to talk about transition and what we need to include in the IEP to help them be successful with college or career. Okay, all right, I'm going to keep going here and then we'll have a time for break so I can get caught up with the comments that are going on in the chat. Okay, so the individualized education program, this is just a summary so that you have a one-page summary. Basically should ensure that the child reaches their goal. The IEP should also have sections on the service needs and time for the child as to what services are when and how often. Statement about least restrictive environment, accommodations, modifications, and support. Program support for school personnel. That's where we talked about before last week about training for school staff. Statewide assessments, and depending on the child's needs, a positive behavior support plan. Okay, again, just to recap, the goals in the IEP are goals that the child needs to build skill and develop in order to be successful in the school environment. And so it's not just academic. We say successful in school, but school is beyond academics, right? It's behavioral, functional, developmental, social, whatever the skills are that the child needs to be successful, that should be thought of as potential goals or future goals for the child. The IEP team will measure improvement on those goals and provide progress reports. And your goals should be set at minimum yearly. That's when you do your annual review, and should change to help your child to continue to be challenged at school. And they should be challenged. Your child as an individual needs to be challenged, right? So if a student is really struggling in math, we don't just stick and do, single digit addition for, all of 4th grade. We need to work on trying to build their skill, but making it attainable, but also challenging, right? So it's kind of a seesaw of a balance there. Okay, goals are based on present levels of academic performance and functional performance, as well as that comprehensive evaluation. The present level and comprehensive evaluation should identify the child's strengths, academic levels, behavioral needs, social skills, functional skills. It should include anything that's a concern for that child. Okay, so how to determine if a goal is a good goal? Each goal will name the skill or behavior the child should learn and progress that they will make. Each goal will be attainable, but challenging. And we need to think ahead about where the child should be in a year. I had an IEP meeting yesterday where we were talking about where the child should be in a year, and one person just asked me to make up a goal, and I was like, well, I guess, I don't really know where we should be. And luckily, the special education director jumped in and is like, well, let's look at where we're supposed to be for this child's age, and where we're looking at with where her starting point is and where we want her to be with her peers, right? So we need to have that conversation rather than just Laura Eisner making up a goal. We don't want that. Not without knowing more information, right? So each goal will explain what skill will be measured and who will be measuring that skill. Okay, progress reporting. There were some questions about this last time as well, I think, or 2 times ago. Our progress reporting should be very clear, and it should be listed on the first page of your IEP about how often you're going to get progress reports. So basically, your IEP goals should list who's going to measure it and who's going to see what's happening. Are we doing speech? Are we doing reading, math? Are we going to see if they can follow the 8-step directive to wash their hands? Right? What are we measuring? So we have to know the goal, and we need to know who's collecting the information as to how they're going to be successful. And then we have to put that together in a way that is communicated with the whole IEP team about how they are getting towards that goal. On the first page of your IEP, it should say how often progress reports are distributed. A progress report is a periodic report on the progress the child is making towards meeting the annual goal. It should not be an IEP team meeting. It should not be an annual IEP review or revision. It should be a document or a report that is created by the team or the assigned person collecting the data that outlines how the child is doing on reaching this goal. It can be through the use of like quarterly or other periodic reports, can be concurrent with the issuance of report cards. I mentioned previously, also there's a case that says that it doesn't have to be, that this is an example of how it can be distributed. It can be distributed in other ways and it doesn't have to match. Grades are not goals, and our goal measurement doesn't necessarily need to follow our grade distribution. Okay. The purpose of data collection, just to cover that quick, is you have your IEP goals, you have the people that collect the data, and they should be collecting it in a way that helps us understand as the IEP team if the services and supports that are being offered to the child are helping them make progress and reach their goals. Data collection should be individualized and it should be focused on the goals of that student. We talked last week about how there was different ways that people had done data collection. Some of it had been done, but there were still questions about like what was happening underneath, you know, and behind the scenes. And some of it was just worksheets without dates or times or information. So we need to have some evidence-based or reliably based way of collecting data to make sure that our child's meeting the goal. That is really the distinguishing point between a 504 plan and an IEP. Is your 504 plan has all these supports, accommodations, modifications, different services that could be in place for the child to make sure that barriers are removed so that they can be successful. Whereas your IEP has goals that need to be measured and reported based on those progress reports. Like that is critical, right? Otherwise, if you don't have this data collection, proper goal writing, progress report piece, you have a 504 plan with a lot more paperwork. So having this goal aspect that has proper and helpful collection of data that turns into measuring progress is what makes an IEP so helpful for students. And without that, it just can cause a lot of stress for families and for school staff because they don't know what's being missed, what services aren't being offered or should be offered, or are offering no supports. So okay, so we're going to take a 10-minute break because we're at noon. We will come back and we will do some questions. I know that there's some in the chat, so we can talk about those when we come back. All right, thank you. Ahead. Thank you, Ruben. And I apologize to him, not that anybody cares, but I apologize for missing his beginning part, but he will record it and we'll just mash it together to better fit later today or tomorrow or something. So, okay, so let's see here. There's a question from Jonathan about notice and parent and student participation in the IEP process. What provisions are currently being made to make sure the process is more accessible for parents with a disability, and how can those be enforced if materials are not being provided in an accessible manner or meetings are not being staged in an accessible manner? So in the idea, and I can send out the law afterwards here, it does have that basically the school needs to do whatever possible to make things accessible for parents. And so my first step would be just to communicate to the school about what the struggle is. If it's, I don't read English or I can't miss work all the time, you know, I need to have a Zoom meeting at a different time, whatever that accessibility issue is, I would make sure that that's being addressed. But then if there's things that are being brought up that are just being rejected on a regular basis, I think I can send out that law again, Jonathan, I'll put it in an email out later today, but that will have something that you can point to at least that says like, it says here that you're supposed to make this, make participation, you know, available for me, and without blank, without whatever, it's not being made available to me. Sue Thomas had pointed out that there is a statute or idea, federal section that talks about when a child goes on to their post-secondary goals. I have it here. I will also include that in an email. It talks about, in this piece, about having a summary from the school on the child's academic achievement and functional performance that can assist the child in meeting their post-secondary goals. I think also just communicating with the new school.
Hey, Laura,
yeah,
did you mean to share your presentation?
I will in a second here. Yeah, I
Okay.
just wanted to, sorry,
Gotcha.
thanks.
Thank you.
Thanks for checking. But just, I guess gathering this information would be a good way to try to transition to help the child after. But in planning for this, I would also look at the transition piece of the IEP and making sure that that is properly developed and has skills and the whatever aspects of the child is life that they're struggling in with school properly designated and outlined in the transition planning for the IEP. And actually, this is a transition is a whole thing. And so I can just put this together as a separate email and a note, and we can get out information on transition. But that will probably be next week, just for people. Okay, there's a question about what if students are struggling because they are gifted and have learning disabilities. So there is a thing called, it's a phrase called twice exceptional students. We have actually, I have some stuff written up for responding to this already because a different person had asked a question on this. But most, I guess, if the struggle is because they're gifted and not being challenged, that is a different question than if they're struggling and with some sort of learning disability, but the academics are there or whatever, right? So I think, I guess the question, the way that I'm reading it is if they are gifted, but they're not getting the services that they need or the education they need from gifted education because of the learning disability, is having an IEP meeting to talk about with that team about how to access that gifted education. Is it making sure that they have the busing to get to the high school to do math? Do they need to have special supports in place to help them access whatever gifted education programming is in place? Just kind of working through that. And I would start first with the IEP team to problem solve that. A lot of the schools, not all, but I think a lot of them have someone specifically assigned. Sometimes I think the roles are shared between gifted education and then the person might do other things, but connecting and building a relationship with that gifted education coordinator to talk about how it actually works and what might be implemented. Gifted education is a whole other topic aside and outside of IEPs. And our team, that ELAP team, we have a fact sheet on gifted education, so I can share that with the team, with the group afterwards as well. Okay, and then there's discussion about that. Okay, yeah, so the last question is about how to work around a situation where you're trying to get an IEP evaluation, but there's truancy concerns and basically being a chicken and egg situation. An IEP evaluation can be requested. If there's a need for the child to be evaluated, like if the child has been identified as a child with a disability and there's a need for the child to be evaluated, attendance can cause difficulties because how do you assess a child in their academic environment if they're not there? I think some of the ways that families have worked around this or tried to navigate this a little bit is developing a plan with how to get information from outside resources to the school to share that information. Maybe they have doctor's notes or medical records, things that would tie to that child's disability. And explanation as to maybe why they're missing some of the school day or the attendance concerns. Having the evaluation completed, maybe there would be a conversation with the IEP team about having that deadline extended beyond that 30 or the school day deadline. And just saying like, well, we know it's going to be a while for him to like try to rebuild his acclimation to the school building, just having a discussion about whether or not that could be a pathway moving forward to have some flexibility on that. But yes, absolutely. There's a lot of, I guess I would say chicken and egg situations where you have a kid that clearly has a mental health issue that is impacting their attendance, and getting them evaluated for an IEP can be really difficult if they're not in the building. But having blunt conversations where as much information outside of the school is gathered to help support the school and understanding where the child is at would be, I think, the first critical step in having that conversation with the school, and then Assessments can be done in other forms of ways. We have children that are doing online learning that are being assessed for IEP evaluations. So they meet with people in person at different, like maybe the public school down the street, or the library to do an assessment, even though they're, not actually in the building with that child. So there are other ways to try to work and navigate this, but it can be difficult. It's definitely not an easy situation at all to try to manage attendance plus getting an evaluation completed. Okay, all right, I'm gonna start going on with the dispute resolution piece here. And then we'll have, okay. Okay, so we did our questions, we did our break. Okay, so we're gonna talk about dispute resolution. So having an IEP meeting is really the very first step to address any educational or IEP concerns. So we need to have that notice of team meeting that Ruben had talked about earlier, provided to the team. And agendas can be used to help keep the team on point or address specific concerns or issues. Agenda topics can be outlined by both the school, the district, and the parent. This is an option. And I've used this a couple of times with my families just to help narrow down the focus of our issues with an IEP or concerns. So I just did a really very basic example agenda. So we put the date, time, and location of our meeting. We do our introductions. Sometimes it depends on the meetings I've had in the past, but sometimes I'll ask like that someone's identified as the note taker with the school, just so we know like who to make sure understands what we're sharing if they are going to take notes, or someone needs to be documenting what changes we're making to the IEP. So who's going to be doing that? If there's particular concerns that the parent wants to voice, or maybe a teacher wants to voice, or an outside professional wants to voice, we can put that on the agenda just to say we want to have a discussion about one-on-one para support and how that looks, or transportation, or having the assessments done in a different time and place than their peers. The parent will identify concerns about IEP typos and misstatements, request copies of certain things to come home, just very general, basic agenda. But this is something that we've created on our side of the things as a parent going to an IEP meeting, just to help the IEP team understand before we go into the meeting what the main concerns are. Usually we've communicated this many times before, with our emails, phone calls, whatnot, but it's nice to have a document that says like, this is how we're hoping to address this, and present our concerns to the school. Okay, so we have our IEP team meeting. We talk about our concerns. So if we have a concern that our child needs a one-on-one para, we would talk about that with the school and then present whatever information we have, outside supports, concerns. Maybe a teacher can come and talk about, yes, this child really is struggling to regulate or navigate the day or understand social interactions, and a one-on-one para maybe during certain times or all day would be beneficial, whatever that is. We have shared that information during the IEP team meeting. After our meeting with the team, we should be sent home that prior written notice. It's called a PWN. And just think about it as a written notice. And this is a tool that documents proposals or refusals by a school district to the parent. So maybe the school agrees. We went to the meeting and we said, we really need a one-on-one para. This is why. Everybody presented information, talked about it. The teachers agreed. And the school then would say, okay, we're going to put together a PWN that says we are proposing to add a one-on-one para with the student, and they need to also amend the IEP and add it in there, right? So then you would get the prior written notice with the IEP. But anything that's communicated in this meeting should be proposed in an IEP or refused in an IEP and sent to the parent. The parent can object to the IEP on a PWN then, if they don't agree with the proposal, or if the school district is refusing to do something that was requested by the parent. So if the school district refuses our one-on-one para request, and they put that in the PWN, says like, we have thought about it and the child just doesn't need a one-on-one para, then the parent can get this document that refuses their request and object. Or if the school says, you know what, the student really is struggling to be at a setting 1, we really need to bump up to a 2 to offer more supports for the child. So that means some of the time they are going to be spending with their outside of the general education room with their special education peers in a special education room, right? So we're going to be at a level 2 or a level 3 or level 4, whatever. We're recommending some higher level, or we're recommending maybe the proposal is to take away a para, right? Like whatever their proposal is, and they put it in the PWN, the parent doesn't agree, they can object. Okay, so your PWN has to have an explanation as to what action is being proposed or refused by the school, and they have to describe and provide an explanation as to that they describe what's being relied on when they're making that decision. So maybe they, you know, the child's behaviors have increased and there's been like a numerous suspensions that have happened. And so they're proposing a level 4. So they need to say like, we've looked at maybe the behavioral data or the suspension records or whatever, right? They have to provide at least some information as to why they're making their decision and other factors that were relevant to their proposal or refusal. The PWN has to have other options that were considered by the team. Maybe the team considered the parent's request for a one-on-one para, but that option was rejected because the child doesn't need it. Or the parent considered a one-on-one para for the full day, but they're rejecting that because that's not appropriate, but maybe during, you know, afternoon classes because that's when the child is acting out the most, whatever they've considered, but that were rejected should be listed in your PWN as well. And the PWN must include a statement about the parents of the child with a disability have under procedural safeguards and resources or sources for the parent to contact to obtain assistance. Okay, so I have my examples for the PWN. Here's our PWN. This is one, actually, the parent got this for an initial comprehensive evaluation. So we had that pre-evaluation meeting. We talked with the couple key players of the school and brainstormed about what we wanted to have in the evaluation process. Like what did we need to have assessed? And so they had listed out the area, what assessment would be done or evaluation would be done, and who's going to be doing it so that they have somebody assigned. So, you know, for like transition, they're going to do a student interview. They're doing this online career inventory and a parent interview. And the special education teacher is going to do that. For other, which the parent objected to this one, but part of the reason was other wasn't clear to us, but they're going to do a parent input and assistive technology considerations. We weren't sure if parent input was for assistive technology or assistive technology considerations was some sort of assessment. It was not clear. But there are some other concerns that the parent had about this pre-evaluation PWN that was sent to her. Okay, so often it's the 4th page of your PWN, but not always, but often 4th page of your PWN has your list here of how you can respond. So because this is an initial evaluation, the school won't evaluate. Even if the parent didn't respond, like nothing would happen, right? So it would just stop. So versus like a reevaluation, right? If you're gonna have a reevaluation and you get your PWN that lists what's gonna be done, if you don't respond on a reevaluation, like you're already in the IEP processes, you have one developed, you're gonna do the reevaluation. If you don't respond, it's considered a consent. But because it's initial and it's the very first time, you have to consent if you want anything to happen. Well, of course she objected because we had questions. And so there's 2 places that she can click to object. I do not agree and I request a conciliation conference. I do not agree and I request a meeting with the appropriate members of my child's IEP team. And then she can list if information here as to like what was being objected to, sign and date. Okay, so just to note this one, when we went back, we listed out all of the concerns and some questions about like, why is this called other? And, you know, it just says observations. What does that mean? Is that for specific things? Why are you observing the child? So in the PWN on the first page, they listed that we had asked for clarification. And so they then, because we had asked, they listed the proposed following updates to the initial evaluation plan. So they put in the PWN everything that they had changed. And it was a very clear communication tool or document that summarized, we wanted to have an evaluation, but we need things that are straightened out and clear for the parent and the school to move forward and know what they're doing. And so they actually listed out, this is taken from my letter that I wrote to the school, but they had listed out this and to add clarity about what they were doing to the grid. And then we go to the grid and they made all the changes, right? So observation is gone and other is now assistive technology. And they added actually something different here. Instead of that consideration language, right? Now we have the student environment tasks and tools, which is some sort of assessment. Observations was deleted and plugged into specific sections, right? So we have observations for academic performance, observations for social emotional behavior, right? And so it's clear as to who's doing what and why. I mean, essentially we needed to know to what end are we doing an observation? Are you just going to watch her? Because that doesn't help us understand what you're going to gather. And it's nice to know what we're going to predict. Not that we know the information itself, but like, what are you going to tell us in an evaluation? Why were you observing her? What does that even mean? So now we know for the observation from the school psychologist, it's for social emotional behavioral. So when we get that evaluation completed and we look through it, we can make sure it was done and understand, the school psychologist did a classroom observation on social emotional behavioral. This is what she found. Okay. No, our parent, she agreed to this one, right? So because this is an initial one, she had to click consent. I agree to the school district. So I agree. So the school district will proceed with the proposed or refused actions in the prior written notice. She had to click consent, sign, and date, and she sent it back. And that started the 30-day school day timeline to get the evaluation going, or done, I should say. 30 days to get it done. Okay, so to be clear about the objections piece, if you do disagree with what's being offered or stated in the PWN, they had the two choices, right? So we had the conciliation conference or a meeting with the appropriate members of my child's IEP team. So meeting with the appropriate members of my child's IEP team, that's often available as an option on PWNs. If selected, information as to what concerns should be shared before you meet with the team. Just really helps make sure that you get the right members of the appropriate members of the IEP team to show up to your team meeting. But you can list it on the document. I've had parents where they write like, I objected at the meeting about, the level change or whatever. I will send you an email with more information, right? And so like it's documented on the PWN and then they send out an email that has like all of the concerns, right? And so it just is clear as to like what's happening and what the parent's problem is or the concern is with what's being proposed or refused by the school. Okay, so here it is again. Our other one is I request a conciliation conference to be held within 10 days from the date the school district receives this request to resolve my concerns and understand the school district will not proceed with the proposed or refused action in the prior written notice. Okay, so if she objected and asked for the conciliation conference, this is often listed in a PWN. This option would be appropriate if the parent disagrees with the school district's proposed or refusal of a PWN and was seeking a quick response. So if you want to have, let's see, you want the one-on-one para, right? That was one of our examples. If you want that one-on-one para, it's really critical that we have some quick responses or hopefully quick movement on it. A conciliation conference could be a good path to have that conversation in 10 days. It has 10 calendar days. So if you have a conciliation conference or your general IEP meetings, dispute resolutions that we'll go through a little bit here are all still available. This does not prohibit the use of a conciliation conference, does not prohibit parents or schools from using other dispute resolution options to navigate conflict. So the conciliation conference, Minnesota has very specific information on this. The parent is entitled to at least one conciliation conference if the parent objects to a PWN. It must be scheduled within that 10 calendar days after this parent objects and returns the document. So if you object and then don't hand it in for like 5 days, they're going to base it on when they receive it so they can have time to plan it. Within 5 school days after the conciliation conference, the school district must provide the parent a conciliation conference memorandum that describes the district's final proposed offer of service. If you make this request to have this quick turnaround and address the conciliation issues, it could result in some of the IEP team members not attending the conference because it's just critical members of making this decision, whatever it is. And usually it has a school district representative, parent, but it doesn't always have, often, depending on the type of school, doesn't have all the IEP team members. So if you have certain issues, you want to make sure that that's properly communicated with the team or your contacts with the school to make sure that people are there that need to be there. I've had, honestly, every school seems to be handling the conciliation conferences just a slightly bit different. I've had some schools where anytime a parent objects, no matter like what's happening or where we're at with communication or what box is checked, they put it on for a conciliation conference, which is nice. We have a quick timeline that way, but we just need to make sure the right people are there. I've had other schools where if they hold the conciliation conference as much more formal than an IEP team meeting. And so if you bring up things that are not in that PWN that are being objected to, the conciliation conference team won't address it. Versus some schools they do, and they just want to try to resolve the issue, and other schools are like very formal on whatever particular issue was listed in the PWN. So that's just something to consider when you're filling out the PWN. Okay. Another dispute resolution option for special education students and their families is, and the schools, of course, is a facilitated team meeting. I abbreviated it here so I didn't have to write it out and take up the space. So this option is not often listed on a PWN, but it is an option if there's an objection, just so you know. The facilitated team meeting is basically where you would have a neutral third party review the IEP with you and your IEP team. You go through the program, or the IEP plan, right? Point by point to talk about what the concerns are, or if there are concerns on each page. And then there's frequently asked questions. This is MTE's information, and then they have a form. So I'm just gonna click on it. Ruben, will you let me know if you can see this form? Oops, dang it. Okay.
Yes.
Can you see my screen? It's coming up here slow. Okay. Hopefully it will load. Okay, so this is the facilitated team meeting request form. Has some basic information about where you're at with your IEP development. Do you have an annual meeting, an initial meeting? Is it something else? Has the district proposed an IEP? When's the annual review? Whatever, last meetings. And then you have to put in information from the school, the student, and then it has conditions here that are listed that everybody needs to agree to. Basically, MTE provides the facilitator. The facilitated team meetings voluntary, and it cannot be used to delay. Like if a parent decides they want to go forward with a due process hearing. The facilitation will only occur if the team members are present or excused in accordance with the statutes, and the facilitator cannot be called to testify. Basically, they just ask that people cooperate in good faith to try to get this wrapped up here. And then the parent would fill this out, date, if they want to be in person, virtual, or they don't have a preference, if they need an interpreter and what language. If communication is difficult between the parent and the educators, yes or no. Sometimes schools have really good relationships with the parents and they're just struggling to like navigate giant IEPs. Sometimes the communication is broken down. It just kind of explains here. You can say yes and then explain. And then we have concerns about the following areas of the IEP. So you can list, is it the identification, goals, services, progress reporting? What are the concerns that you have? If you have concerns about a lot of things, you can click them all and, document it all and send it to the facilitator and the school so that they have information and can work together and with you, during the meeting to figure out next steps and navigate it. And then if you've been working with an advocate or attorney, you can fill this out. And then the district has to fill out very similar information here. And then it has to go to the Department of Education. Okay, so mediation also is an option, not listed on PWNs often. In fact, I don't think I've ever seen it, but it is an option if you disagree with the PWN to mediate, and you could do a neutral third party. Well, paperwork, if you do the paperwork, a neutral third party will be assigned to help you navigate the dispute. All parties must agree to participate. This is similar. Let's see if I can get the form up here. Department of Education has the form. They provide the mediator at no cost to the parties. Well, this is the download one. And there's set up a little bit different. We'll go through that in just a second here. Very similar. Is the mediation a result of a hearing request? We'll actually talk about hearings in a second here. So this is an option also if there's a hearing. If there was a conciliation meeting, put in that date there. Again, mediation's voluntary, it's confidential. You cannot get them to testify. Documents should not be participants should be recorded mediation sessions. Basically it allows I request the mediator to be assigned to assist in resolving the following issues, and you can type in the concerns and add extra information, and then the same if they have the district fill out information. People have to agree, right? And so if you have a side that's not willing to mediate or do a facilitated team meeting, then these options are not available. But I think at least sitting down, there are sometimes things that can be addressed or at least shared in a mediation where the third party mediator or the third party facilitated team meeting person that runs it can help even just sort out some of the communication difficulties if people are maybe not using the same terms or language or whatever. Just it is a good option to try to sit down with the team if at all possible. And communication might be difficult, but having this third party person can really help out. So okay, I stole this from MDE's website, so I noted it up here. But mediation has different types of stages, and I just thought it'd be helpful for folks if they were thinking about using this option to refer to this. So the mediator, then when they start out, they meet the team, they talk about how everything's handled in a mediation. There's ability for people to take breaks and use private meeting spaces to talk. Questions can be, proposed to the mediator. They can try to respond to those questions early on. Parties will take time to define the issues from their point of view. And the mediator might try to flush out some questions or concerns, or if there's confusion on how things are being said, just to try to summarize that as well and make sure everybody's on the same page. The caucus is an option if you need to discuss things. I did a mediation a couple months ago, and we did use a caucus, I think only once, but it was really nice to just give a moment for the client to kind of decompress, ask me questions outside of the school and the mediator, and we can come back. The mediator will help the parties identify different options that are possible for resolution. And then there'll be a written agreement that's typed up at the end of it, and then the parent and then the school district representative signs this agreement. And then there's this wonderful chart. I won't click on it, but it's in here when the slides go out, that compares facilitated team meetings versus mediation and when it might be appropriate to use one or the other. And MDE will help sort through this as well. I've had clients that have wanted mediation, but having a facilitated team meeting at least was our first step that I think helped sort through some of the topics and concerns that the parents had and the school were willing to resolve. But if you can't get everything wrapped up on a facilitated team meeting, you can still use mediation afterwards. All right, you can also do a special education complaint. A complaint would be filed with the Minnesota Department of Education on violations of the child's IEP. So if the school says that they're going to do something and it's not done, violations of IDEA. So if the school knows that, I don't know, doesn't do the child find, requirements, or they failed to send out the PWNs, they hold an IEP meeting without telling the parent, whatever that is. If they violated the IEP itself or violations of IDEA, the special education complaint can be done. There is a 1-year look back period. So basically, whenever you file this investigation, assigned investigator from MDE can look back 1 year. So if I filed today, August 24th of 2023, the investigator can look all the way back through August 24th of 2022 and assess that time period. If this complaint is completed, it needs to be sent to the school district as well. and I'll pull up this complaint here real quick. This is the link here is to the PDF document, so just know that when you open it, it has essentially 3 questions. I mean, you have to fill in your information so people can contact you and know who the school is, but 3 meaningful questions about why this would be filed. Statement of the alleged violation, so you need to have a description of the problem, a statement of facts, so you need to describe what happened. So here they even have examples. The teachers were not following my child's IEP. My child's IEP states that my child will not be seated in the front of the class, or that child will be seated in the front of the class and he's seated in the back, right? Or like my child is permitted to take breaks when she requests it, and she asked for it on several occasions last year and it was not honored, or whatever, right? Needs to have event dates and anything that would support your allegation about what happened that led to the violation. And then describing your proposal suggestions to resolve the allegation. So you want your teachers to receive training on a specific disability. If there is, maybe the child needs some tutoring to make up some missed education, whatever it is that needs to be provided here, just to help kind of sort through if this investigation is, if there is a finding that there was a violation, that the investigator has some direction as to what you're looking for an outcome of this. And then just who you sent it to at the school and sign and date. So easy enough. They do ask in here, it says it's not required, but it is helpful if you send this copy of the student's most recent IEP, or if you're doing the individual family service plan, to send that. If you have other documentation, text messages, emails, other communication that would support your allegations, obviously send that as well. And they have this wonderful email that will accept it all, and they will get it out, sorted out for you. So let's see here. I also included on here just some information. So if you have questions kind of about the process, that's also MDE's website. Honestly, they have some of the best information on MDE. I sent my clients and people that call in there all the time just because they have great resources and it's really easy to understand. Okay, so we're going to jump over to due process complaints. This can be done for special education students if there is a disagreement related to identification of the student, evaluation of the student, educational placement, or provisions of a free and appropriate public education. We talked about FAPE before. I think that was the first session. So, but if there was something that was missed, child wasn't permitted to be involved with speech education in their general education classroom, that might be a concern that the child wasn't offered a free and appropriate education fully because they missed out on some service requirements that are in the IEP that weren't provided. So a complaint can be provided, or sorry, can be written based on one of these disagreements, or it can be written on a disciplinary matter. And then if that's done, there's actually an expedited path for due process complaints. If you decide to do a due process complaint, basically you're filing a document. It goes to MDE, but they get it to the court and it goes through an Office of Administrative Hearing process, where then it would be like a little trial where people would talk about the concerns that you have alleged in the complaint. There's a two-year look back period. So instead of August of 2020, or if I filed today, August 2023, it would be August of 2021, right? So they would have the 2-year look back period for the judge to consider. Complaint has to go to MDE. They get it to the the Office of Administrative Hearings for you, and it has to be given to the school district. Obviously, you can't have a trial without other people knowing that there's a trial. So just the communication. So there is a complaint and hearing request form document here. I'm not going to open it up because I need to get through my slides. Frequently asked questions, and then the OAH, sorry, has a great video on how trials are to be handled. It is probably a scenario that most families are not wanting to address because doing a trial can be, complex and take up a lot of time. But it is an option, and the video is very helpful. I thought it was just a great video. Actually, when I had cases that went to OHH last summer, I sent this video to my clients just so they kind of understood the process, and then they could rewatch it on their own time, in addition to me explaining court. So, okay, other possible responses if there's a disagreement. So if you have a disagreement about how things have been handled or being handled, parents have written parent input letters, and parent input should be included in an IEP. So you can just submit the letter and it could be included in the IEP. It's not super forceful, right? Like you're not gonna like go to court or talk to a mediator, but it is a way to document, you know, if there has been struggles on getting things done. I had one parent that wrote in her parent input letter, she'd been asking for an IEP for 2 years and they finally got one. And it took because there was this delay in getting anything done. So, I mean, there was other remedies and dispute resolution options for her. But one of them, she opted to write in her parent input letter that she had been asking for an IEP for her child for 2 years. And we finally got it and we included that in the IEP because that was part of her letter for parent input, which adds even just feedback for the staff working with the student to understand that he's been struggling with academics or behaviors or whatnot since at least the parent had identified it 2 years ago. There's an All About Me booklet. There's like templates online. I also have one that we've used with a couple of clients. And basically it's just a nice little booklet that's just talks about some things that work and don't work and awesome things about kids, you know, and so then a parent can take it and put it together about for their own child and hand it to some of their staff. The nice thing about this is it has a lot of information that might not be in the IEP because the parent wrote it based on like current and where the child is, you know, if they're really loving, you know, I don't know, watching Peppa Pig or, you know, whatever, I don't know, some sort of cartoon. I'm just thinking Blippi because that's all like we watch at home. But you know, whatever they're really like super into right now to help staff work with the child. So I think there's also a concern, of course, if you have this so much paper, are they going to choose to read the easy stuff and not the IEP? I guess there's a concern about that. But that is a pathway depending on your relationship with the school and trying to navigate concerns or questions. If there's behavioral concerns or academic concerns that are not being fully addressed in IEP meeting and services and supports really aren't meeting what that child needs, requesting a reevaluation could be an option, right? Or an independent educational evaluation. Like we talked about a little bit ago. There's also an ability to request a standalone FBA, which we'll go into in just a second here. The FBA means functional behavioral assessment. There is a case, it's out of a different state, but it's federal law, so just beware. There is a case that had said that a standalone FBA, so the functional behavioral assessment, that's by itself. If the parents object to it or don't agree with it, they don't necessarily get to come back and ask for that independent educational evaluation because it was just this little piece of that, right? It was just a one little assessment rather than a full evaluation. So just be aware that that is at least a case that's out there. Okay, so for the reevaluation, we talked about a lot about this, but if a parent disagrees with the IEP and how it's being implemented or services aren't being done, or after COVID, we all came back and child has significant mental health struggles, delays in their academics because they did online school and didn't log in or didn't understand anything, maybe a reevaluation is appropriate to help us kind of regroup. If we get that reevaluation and we don't agree with it, having that independent evaluation could be another pathway that's available. However, if the school doesn't want to provide the independent education evaluation, they could push for the hearing option rather than paying. So that is available, but it doesn't necessarily mean it's going to happen, right? Now, the functional behavioral assessment is defined in Minnesota rule, and it says that a functional behavioral assessment must have certain things in it to assess in gathering information to maximize the efficiency of behavioral supports for that child. So we need to have descriptions of problem behaviors, identification of events, times, situations, like triggers, like what are we looking at here for the student? Are there certain incidents or consequences or reinforces that maintain the behavior? What are the functions of the behavior? All of this needs to be assessed in our functional behavioral assessment. And if we have a child that's having significant behavioral struggles in school, possibly having a functional behavioral assessment done would be appropriate. And that's what Ruben had talked about with the manifestation determination review, is if you have a child that's having a number of suspensions, right? We're adding up our suspensions and we're seeing that it is tied to behavior, or sorry, that the disability is tied to behavior. Having a functional behavioral assessment might be helpful because we can build up a positive behavior support plan or revamp the one we have. If there's other concerns though, beyond just behavior, if it's academic or learning, or we think that the behavior is tied because they're struggling in learning in a way that we don't understand, having a full reevaluation would offer more information than just the functional behavioral assessment, because functional behavioral assessment just looks at behavior. Okay, so, oh man. Okay, so other dispute options that are available. We have a couple ones that I just wanted to list out just so people have the information. 504 plan dispute resolution option. So if you disagree with your school on the 504 plan, obviously having that school meeting, kind of like an IEP meeting, but having the school meeting with about the 504 plan is an option, and usually a great first step to try to navigate whatever concerns are going on. If there's a 504 plan in place that's not being followed and there's just concerns about how there's apathy towards the plan or an unwillingness to comply with the plan, there can be a filing with the Office of Civil Rights. And there's a complaint that goes that way to the U.S. Department of Education, and they'll investigate it. A part of that is to do a mediation if the parents and the school agree. So that could be included as well. And then of course there's a lawsuit path. Maltreatment. This is a complaint that will be made to the Department of Education. Maltreatment complaints are for investigators to look into allegations of physical abuse, sexual abuse, or neglect. There's information on how to file, and if you have questions about any of maltreatment, there is a phone number on the website for MDE and an email address. You can just contact them. There's also a complaint form that can be done, or that would need to be done if this is the route you're going to go, about that would outline the allegations, events that would have led up to the allegations, any sort of details about who, what, where, when, why. Okay, the Safe and Supportive School Technical Assistance Center. This is part of MDE. The Department of Education has this assistance center. If there's any concern about bullying, a school failing to comply with bullying policies, the law, contacting the Technical Assistance Center is a great way for parents to try to sort through their options. There's a phone number, website's here as well. They will share different pathways that the parent could consider to move forward. And if there's an impasse or things have already been done and not responded to, there's a formal complaint that can be done. And then Department of Education has investigators that will investigate this Safe and Supportive School Act and see if there's violations by the school of the act. So the Minnesota Department of Human Rights is a complaint process option for dispute resolution as well. If there's concerns that the child was discriminated against based on disability, race, gender, another protective status, their investigation has a 1-year look back period. So again, if you filed today, you would have until look back to 2023. Their discrimination form is easy and can be completed on their website. It's not like a separate form that needs to be filled out and then saved and shared. This is like an online form for people. Now, if you fill this out, it doesn't mean that there's a charge of discrimination. They will gather information based on what you've put here. I think they set up like an interview process to talk about that, and then they determine what next steps would be. So it's easy, but once you're done here, it's like a Google Forms or whatever. You submit it and it goes to them. They have a spot where you can share documents if you have that accessible, but otherwise, if you put in your incident that you have documents, they can work with you to get that from you. And then here it lists that like what you were discriminated against: race, disability, sex, age, color, national origins, religion, sexual orientation, gender identity, public assistance, marital status, family status, creed, other. And then also it's on this slideshow here as well, but the chart that's available here on this reporting page is really nice to understand where you are in their process of their investigation. And this also offers a mediation path as well. So let's see here. Okay, the Office of Civil Rights, this is with the U.S. Department of Education, right? They investigate 504 plans like we talked about, but they also investigate complaints about Americans with Disability Act, Title IX, so anything sexual harassment related. I mean, there's not anything, but it's sexual harassment related in the school building, and civil rights retaliation. There's one complaint for all of these, and then you just go through and you check off which box would apply to you. This is a 60 days within the discrimination allegation incident. There is a waiver on there to ask that they look beyond the 6 months. 6 months, I apologize. 6-month time frame. I don't know how often that's granted, but it is a provision in the complaint that they can be filled out. There has to be a consent form when you send in the complaint. It's actually part of the whole packet. The consent form must be signed with a pen. It can't be signed electronically. They prefer, I guess people are working remotely with them still, so they prefer email or fax. Snail mail shouldn't be used. Oops, sorry about that. And the OCR is very responsive. Actually, the Chicago office is pretty good. They call back in about 24 business hours to respond to calls. And then here's just some more information on the OCR, the Investigation Authority, which we'll talk about like what can be filed, what they look at, and the processing procedure. And then FERPA. This is the violation of the Family Education Rights and Privacy Act, or FERPA. So again, this is a 6-month look back time period. So 6 months since you knew about the alleged violation, or 6 months after you should have known about the violation. Allegations can be on if the child educational records weren't provided to the parent, like the parent was denied access and they had the right to the records, denied the opportunity to amend the child's educational records, or if the child's educational records were or personal identified information were improperly disclosed. So if the information was shared that shouldn't have been shared. This website has great videos on how to file a complaint and what happens after a complaint is filed. The form is here. FERPA complaint can be mailed or emailed. Oh my goodness. Okay. All right. Last slide, and then we'll take questions if anybody wants to stay on. Just some helpful links. I listed some stuff from Pacer. Pacer's a great resource. They have helpful information here. That's here. Our Education Law Advocacy Project team, primarily my supervisor, Lillian, and Annabelle, who was here on some other sessions with us, revamped our handbook. So that was just updated, I think, a week ago properly. So it's linked here if you want it. It has information beyond what we talked about today. And then, of course, Educational Law Advocacy Project, we have fact sheets that are available on our website. So we are eventually going to be moving those over to Minnesota Law Help. But as of right now, we have 5, I think, that are there, and 2 that are, so we have 7 total, but they're like divided between spaces. But right now the fact sheets are on our website, and they're there and available for people to look through. We can go through questions in a second. I'm just going to note one last thing. We'll get out answers to questions that were submitted by the registration. And then also I have to send out a survey as part of our co-sponsor funding that we got through the Minnesota Governor's Council on Developmental Disabilities. The survey will be going out on Monday next week to everybody. And I'll put it in a Google form so you don't have to like fill it out on a separate document and send it back. Okay. It's 1:01. Does anybody have any questions? Otherwise, people can log off and we'll be in contact next week. I can't hear you, Ruben.
So I don't see any questions or hands.
Okay.
Nope. Nope.
Okay.
I think they're just thank yous.
Yeah. Okay. Well, thank you all for joining us. We really appreciate your time and sitting through what has been a lot of talking for me. So I appreciate you listening to me. But yes, if you have any questions going forward, feel free to reach out. We can at least help direct you to the right statute or a resource. And then our handbook should have a lot of information for people going forward as well. So thank you.